One, two, one, two. Testing, testing. Two, one, two.
I can hear you, but not the music.
Testing, testing. Okay, that was delayed.
I don't hear the music.
Hello, how are you? Can you hear me?
Can you hear me now? Perfect.
I
Okay,
can
this should
hear
work.
you. Yeah, are you live streaming now, or I thought you were recording it and then going to post?
I mean, what I do is technically a mix of it. I live stream and I record it and I post it. So I don't our promotion are generally on the webinars. We just record it and when actually we post it online. We don't realistically promote them, but at the same time, along the ways, people can see it as a recorded streaming. So I don't know if you're streaming on your channel on YouTube. Are you doing that right now, or you just
No. I'll just upload the video when you're
you upload
done.
the video?
Yeah.
Okay, so let me get a recording going on, and then from there, we can go ahead. Let me see. How can I do the recording here?
Can you see me okay?
Yes, yes, yeah, perfect.
And you can
Yeah,
hear me fine?
yeah, you sound very good. So, I do both because a lot of people on LinkedIn they come in and they ask questions which are very interesting.
Mm-hmm.
So that's
Yeah, that's fine.
okay. So we are going to record right about now. Okay, good evening, everyone. My name is Davey Carcason. I'm actually the founder of Transnational Matters, an international law firm. Today we have Mr. Rivera, who is actually the head counsel of Financial, and I want to give you a little background of who he is and what he does. Mr. Rivera is an adjunct professor teaching international business transaction in criminal law. He's a chief international counsel for Fidelity National Financial, a Fortune 500 company since 2007, and was primarily responsible for the company's global expansion. He opened offices in Mexico and Malta. He established a network of attorneys in 34 countries to work as a company's preferred counsel. He currently manages a multi-million dollar domestic international litigation budget on matters with a combined exposure of over $250 million. He's a frequent guest speaker and lecturer in managing litigation, litigating in multicultural jurisdiction, and managing outside counsel. I graduated from Lewis University School of Law in 1980, studied at the Hague Academy of International Law summer 1979, and also as well, you have like an expansive of history and legal background, Mr. Rivera. It's great to have you here.
Thank you for having me. It's a pleasure to be here. It's a privilege for me interviewed by you, and hope that I'm sure we're going to have a really great discussion.
Absolutely, and we really all look forward to this because you've been exposed into the common law, and you also been exposed into the civil law jurisdictions, which I'm sure you'll be able to comment on both and guide us through what's the differences and what's the pros and cons on each system, and having a very good discussion regarding the matters of both common law and civil law. So that's why today we're going to talk about comparative law and see how these two systems reconcile each other and how we can see for a better future between the two systems. So, Mr. Rivera, basically what I will do is that I will stream a PowerPoint, and from that PowerPoint, we'll go ahead and ask questions. You'll take it away from there. Those are open-ended questions. There's no tricky questions or answers. It's just an open-ended questions based on your experience and your knowledge, your extensive knowledge that you have with all those exposures of civil law and common law issues. Without further ado, we'll go ahead and stream the PowerPoint.
Sure.
Okay, so give me 1 second. Trying to actually get the Zoom going. Okay, let's see. Okay, hopefully we can hear, you can hear me very well. And we are
I can
actually,
hear you.
okay, great, because that's the first time I'm doing it directly from my computer. Just want to give you a heads up.
Mhm.
So normally I do it from like an office and we stream it with a second computer. So it's a little new to me to do this on my own. Okay, so let's do a slideshow right here. Okay, so today we're going to talk about common law and civil law and understanding the difference and similarities. And this is actually what we're going to go for. Basically, we'll have a slide and we have a question, and of course, Mr. Rivera will be able to answer the question based on his experience and his knowledge. Okay, all right, let's go ahead and dive in. So, Mr. Rivera, what is actually the historical background of common law and civil law? What are some similarities that you have been exposed to? And any comments that you have regarding the issues at hand?
Well, I mean, civil law has various origins. One of them is the Napoleonic Code. A number of jurisdictions are based on the original Napoleonic Code. You've got the Roman civil law system, and you've got the common law system, and you have some countries that have a mixture of common law and civil law. For example, even the U.S., in Louisiana, there's civil law, state law, and yet there's federal U.S. law that's involved. So I would say that the key differences between the civil law and the common law system, before I get into that, let me just say that there's a difference in lawyers who practice in civil law systems and common law systems. For example, lawyers in common law systems are used to precedent, are used to cases that form part of the law. It's unusual that in civil law systems you have precedent, although it can happen in some jurisdictions. The jurisdictions I work in, they have what they call jurisprudence, which is not binding on the court. And so the mindset of a civil law attorney is, well, this is what the code says, and if it doesn't say you can't do it, then it's okay. Where if you're a common law attorney, you have to focus not just on what the statutes say, but what the case law says. And so common law attorneys have a tendency, we present evidence orally. For example, the US, everyone knows about trials and jury trials. You've seen them on TV. But for example, in the UK system, you have very small briefs and you have 2 days of argument on a simple motion to dismiss. So the mindset's a little different, okay? And you also cannot lump all civil law countries together, because some civil law countries, it's all documents. It's all documents and that's it. They do have live testimony, but there's no cross-examination, for example, necessarily like you do in the United States. In cases, for example, in Mexico, where, I attend a lot of the trials that I manage, any questions you ask a witness has to be sent in writing for the clerk to read, and maybe you can ask follow-up questions. And an interesting thing is that you cannot have your lawyer present when one of the parties is testifying to avoid influence. Then you look to some of the countries in Europe where you're not allowed to talk to witnesses. That's the purview of the court. So saying civil law is one thing, it's developed differently according to the countries. For example, in Costa Rica, when you have a hearing, you can say, I want to invoke an appeal. The judges go off to a room, they come back, say the appeal's granted or the appeal's denied, okay? So each civil law system has developed historically according to the needs or the development of that country. So to say like Mexico's civil law system is the same as Costa Rica's civil law system or Guatemala, they do have some significant differences. That's the first thing. Don't combine them, okay? A common law system, everybody knows, comes from the UK, but despite the fact that it comes from the UK, is significantly different because of the differences I've mentioned. In the US, we have documents that are, a room full of documents. In the UK and places like Bermuda, Anguilla, where I have matters, you have skeleton arguments, but you spend most of your time arguing.
Okay, so technically, would you say that it is rather more streamlined to have legal issues concerning within the system of civil law, or it's more streamlined into a common law and where actually it's a little more predictive of the outcome of your cases?
I have to say, I don't know that any one is more predictive than the other. I've had cases in the US that I thought I would win and I lost, and cases I thought I was going to lose and I won. You can't really predict any civil law system, okay?
Okay, so technically it's just so on both sides it's not really predictable for attorneys to find out exactly what will be the results of their cases. But that moves to the next question here. Anyways, what is actually common law? How did common law came to be compared to civil law?
Well, common law came from from what I remember, came from the English. Our common law came from the English system, where you have, statutes, you have cases that interpret the statute, and that is how the law is made. You may have a statute in the US that says one thing, but a case law interprets it in something else. It's totally different. So when you're doing research in a common law jurisdiction, you not only have to read the statute, you have to read the cases. And sometimes when the statutes are not clear, and perhaps in the cases are not clear, you have to go to the legislative history of the statute. The other problem in the US system is that you have, all the circuit throughout the United States, and sometimes the law is inconsistent. You may have opposing rulings, which is why sometimes the US Supreme Court will take a case because of the inconsistent rulings on an important issue. In terms of the judges and the role of judges, for example, in Mexico, where I've handled a lot of cases, the judges don't hear the evidence. The evidence is presented in front of a lawyer, law clerk, here's the evidence. They take down the testimony. The judge is not present when the person's testifying. And what I've seen happen in some cases, if there's an issue, for example, whether or not some evidence should be admitted, the law clerk texts the judge comes in and may make a ruling, or the law clerk goes to the judge says it could be admitted or not admitted. At the end of the case, the judge will receive a voluminous file. It will be assigned to somebody to do a preliminary decision, similar to what happens in the States when a federal judge's law clerk basically, prepares a draft for the judge to read. But the judges in the civil law systems I work in, and some of them, are not actually involved in the hearing of the case. And that's because the mindset is what's important is the documentation and not necessarily the live testimony. In countries where they have a notary public, where notary public has to be a lawyer, they get a lot of credence to declarations in front of a notary.
Right, and this is very interesting because I did I don't know, Rudy, can you Mr. Rivera, are you here? Did we lose him? I think we may have lost him. Give me 1 second, see if it's I can contact him to see if we've been cut off. Oh, okay, you're back. I think we got a little issue down with the streaming. Okay, so technically you were speaking about notary, and we're going to dive into the civil law system in a few seconds. But I want to speak about the notary aspects of the differences between the common law system and the civil law system, because when you go and you tell somebody in France that you're not a notary here in Florida, they think that you did like the great studies and everything else, which is very difficult to get over there compared to let's say Florida here, where you just take a test online and you do a sworn statement that you'll be truthful to all the document you will notarize. But how does that come to be? Like, what is what is the pertaining of notary in civil law compared to common law notaries?
Well, in some countries, for example, as in Mexico, the notary public cannot practice law. In the sense the notary public can't represent clients. The notary public is like an extension of the court that takes declarations under oath. When somebody says, I want to make a declaration in front of say, a Mexican notary, that can have a binding effect. Where in other countries, for example, like Guatemala, any lawyer can be a notary public, but the notaries are not limited to to just notarizing documents. And let me backtrack a little bit. So, for example, in Mexico, Ecuador, some places, a notary just does notary work. Any land transfer has to be signed by a notary. If you're divorced and you want to go to Disneyland with your kids, you have to sign in the presence of a notary that says, yes, the non-custodial parent said, or custodial parent said it was okay. People are often surprised when they learn that in the U.S., the notary can be anyone if they pay the filing fee. But the notaries have a specific purpose, and historically they've developed because it was an extension of the court. That's really what it was. And in Mexico, for example, notaries are zoned off. Okay, so you're a notary for a certain area, you have certain jurisdictions, and oftentimes they were inherited positions.
And
And I
and uh and it's very interesting that you say that because I had a recent call from another attorney who said he was a special notary that required to be 5 years in practice and take an exam here in Florida. It's the first time that I heard that. It's not well known that there's only a few attorneys that have that type of notary. Are you aware of something like this here in Florida?
I've never heard of any special notary in Florida or any other state, not to say that it doesn't exist, that talks about that type of situation. I mean, I've never seen it. I know there have been some scandals with people talking to families and saying, I'm a notary, giving the impression that they're a lawyer and charging exorbitant fees for just notarizing simple documents.
Right. And this is something that probably I will do some research on, based on that attorney that has more authority to notarize those documents. But he seems to tell me one day that there's a notary that we have to be 5 years in practice and taking an exam. That's a lot more honorable than notaries without being a lawyer, which dives into the next question on civil law. And so, tell us about a little more about civil law, where how it started, and how did it develop over time? Uh, Go ahead.
Well, I mean, civil law, as I indicated earlier, developed as part of the Napoleonic Code. There are other sources, but that's the one that people mostly know about. And civil law is basically nothing more than statutes. Okay, if the statute says you can do it, then you can do it. If there's something that doesn't prohibit an act, then it means that you can somehow do it. Okay, the role of judges in the civil law systems basically apply the law, but they don't necessarily rely on jurisprudence. Or let me just say, they may read jurisprudence, but it's not it's not binding. Okay, but they may take it under advisement. But they don't have to follow it. And I'd say that civil law is much more rigid than common law. Because if you look at the statute that says you cannot do A, B, and C, then the judge is pretty much limited to that, with the facts he have. Where common law systems, it's more so likely to judicial interpretation by reading other cases and seeing how the courts, have interpreted the law. Um, uh, and like I said, civil law is different in Argentina, it's different in Guatemala, it's different in Ecuador. For example, in Mexico, land transfers can only be through a notary public. But in Argentina, they have the escribano, the scrivener, which, transfers those documents, does those document transfers. Those are, it's a civil law system, but, with different nuances. Okay. And so what's important to note is that the role of notary in civil law systems is different depending on what country you're in. For example, if you look at Puerto Rico is an old, has case law, but they have a registry system that's based on, the same or similar statutes as Mexico, for example. It has a lot more formality. Civil law systems tend to be much more formal than common law systems. They're very rigid when it comes to documentation. So, for example, if your name is Davy, spelled D-A-V, which that's what it is, but if somehow somebody spells it D-A-V-I-E, that document's likely to be rejected because they're going to say, how do I know this is you and not you? Where in the US, you would just cross it out and make the correction and go forward. How many times, Davey, haven't you seen a judgment in the US where the judge writes in the numbers? You don't see that, in civil law systems. So, you can look at flexibility. When you go to the flexibility, you look at, there's not much in the civil law system because this is the law, and I'm oversimplifying it, but this is a law. Common law system, law in the cases. Now, I want to address one more thing. In civil law jurisdictions, generally the judge is the trier of fact and basically makes the decisions on the law because there are very few jury trials. Only recently there's been some legislation passed in Mexico, for example, that's going to allow for jury trials in criminal cases and also in some civil cases, but that's further on down the road. And that poses a new challenge for Mexican lawyers because now they're going to have to learn how to present evidence the way a common law lawyer does.
Right.
And so, when you look at the common law system, there's a little bit more certainty because you can see how judges decide a case. And so, if you're in front of a judge, you can. And also, a number of the civil law systems, the court files are not public information.
Right.
The only time you can get in there is if you have an interest or you get authorization from somebody, but unless you have the power of attorney. And then that's one other thing I want to address on that in terms of the formalism. If I say to you, Davey, I want you to represent me in a case in Florida, and I say, please represent me. And you say, I'm Mike Davey, I represent Rudy Rivera, and you file your pleadings. But in civil law countries, you have to have a formal power of attorney that gives you authorization to represent the insured or the defendant or the plaintiff in any type of litigation. You can't just say, I represent you. Okay. And we can go on, to the next slide, but that's basically in a nutshell some of the key differences. There's a plethora of differences, but for your audience, these are probably some of the most basic differences.
Right. And basically, from my understanding, where we're dealing with arguments in terms of because I'm a huge fan of international arbitration. And there was a discussion at the MIAS, the Miami International Arbitration Society, about discovery. And I see that civil law attorneys absolutely despise discovery. They don't want it. They said this is too long, it's too expensive, we should get rid of it. But American attorney says we need to find discovery as to find out if there's any fraud or anything that we need as information. So that's why we want to expand on discovery, do depositions, look at documents, request more documents. And this is what actually the bulk of arbitration. What's your comment on this?
That's a very interesting question, Davey, for this reason. Civil law lawyers are not used to discovery because it doesn't exist. Okay. And what happens, the mindset is, well, if they don't know about it, I'm not telling them. Where in the US system, you have to be transparent. You have to know your side and you have to know their side in order for you to effectively represent your client and present the case. So yes, civil law lawyers would not be inclined in arbitrations to disclose any information, okay? Where common law lawyers are used to it. You know, it's good and it's bad. I've, you know, handled number of litigation matters in Mexico, for example, some in Guatemala, some in the Ukraine, actually before the war, and Romania and Prague, and that just discovery doesn't exist, you know. And a challenge, for example, just I go back to Mexico because that's where I have the most experience. When you file a petition, a demand, you have to try your case. In other words, you have to present every piece of evidence. And if it's not newly discovered evidence, you can't present it. And then you have, say, 15 days to file an answer. When you file that answer, you have to try your case in that answer. The only evidence you're allowed to bring in is either newly discovered evidence, or you must mention evidence that you want to introduce, but it's not available at the time. For example, you want to get a certified copy from the registry of the chain of title. You know, that's the only time you can do it. So it puts a lot of stress on somebody when you have to present your case. Whereas in the US, this is a huge difference. You file, you know, maybe a 10-page petition alleging basic elements, and you file a general denial, and then you get to know the case in discovery. You don't necessarily have that option. Now, let me point out also a huge difference with those systems when it comes to try to settle a case. You know that in the US, mediation is mandatory in the federal court system. Most state courts will require it. But I have found that in litigation matters, it is extremely difficult to try to mediate and settle a case. And the reason for that is because most of the lawyers are so convinced that they're in the right, that they don't want to go back to their client to say, well, you should settle. Their client will say, well, if you told me we had a great case and we're going to win, why should I settle? Those civil law systems, because of the lack of transparency, are not conducive to a settlement. Where I think in an arbitration where there's disclosure, say, and the arbitrator requires a disclosure, you know, you may be more inclined to try to settle. I had a trial in Costa Rica where we tried to do a mediation beforehand. And I said, well, this is, you know, this is something that we think we're right. And I know you think you're right, but I'm here to try to make a monetary settlement. And the first thing the lawyer said to me was, we're not wrong. We're 100%. And one of the arguments I make to them, I said, you're in the wrong court. And so you know what happened? When we went to trial, we were in trial. The judges said, wait a minute, before you go any further, you're in the wrong court, okay? And I think that the civil law attorneys I've seen in some countries are not in the mindset that they're going to lose the case. And so it's very difficult to settle. And I've tried it on more than one occasion to try to settle, but always it's never been successful.
And in that aspect, because this is very interesting on what you told us about the fact that actually they're not used into the common law system, but when we're dealing about, for example, the European Courts of Human Rights, or in terms of Europe on its own entity, do they have like some sort of common law system, since they have a federal system for these type of courts? When you're talking about the Supreme Court of Europe for appeals purposes, or?
I've never litigated before the European court, so I really couldn't tell you. The cases I've litigated in some of the European countries, there were issues that went up to the European court, okay, but never issues that I was involved in the litigation.
Okay. So, all right. So we're gonna have the next one. coming up. Okay, so technically we talked about the little bit about the already the differences between the common law and the civil law, and you already expanded about the precedents and the flexibility and certainty in those two legal system. But the one I want to really target is the role of the judges, because from my understanding of what you provide us as information on the judge's part, it seems to me that under the civil law system, the judge doesn't have much flexibility into his rulings, whereas in common law, it seems to me that the judges have some sort of discretion or can sway left or right depending on the arguments that's being brought on in front of a judge. Is that correct?
Well, I don't think it's not that they don't have flexibility in their ruling, because the judge has to evaluate the evidence, and make a determination whether someone is credible or somebody is not. Now, because they don't see live cross-examination or live testimony, all they can do is make a judgment based on the documents they receive. But when I say there's a lack of flexibility, is that they say this is what the civil code says, and therefore this is what you have to do. Okay. But the judges do have to make a decision on who they believe or what documents to believe. I mean, you have, say, a real estate dispute where plaintiff says, I've got good title. The defendant says, no, my title is good. Your title is not bad. There, the judge has to make the decision based on the facts. Okay. But I find that the lack of flexibility is there's not a lot to go on in terms of guidance on how to interpret. You're just looking at that case. You may look at other jurisprudence, but you're not going to find, anything that would be of precedential value necessarily.
So technically, it's just that the judge, anyways, will have to evaluate all what's been submitted to the judge in terms to make that decision in civil law. But what does the judge do? What are the resources to the judge to make that decision? Do they have, like, for example, I remember that based in France or Italy, they tend to actually take the Justinian Code, or they have some sort of code to look back onto, and then they have like other. Sometimes they actually evaluate based on previous cases. And so forth. So they refer back to those resources. Is that the same thing for Latin America and other civil law country in the South?
I've been working in Latin America for 30 years, and I've never seen a court decision that relies on jurisprudence. Mostly the reference is made to the part of the civil code that is applicable. So what you will see is a decision that says, this is a civil code that applies. This is a civil code that says you can do this. Okay. And based on what the civil code says, I find in favor of the plaintiff or the defendant for this reason.
And a quick question regarding about the civil code. What would it be comparable or right to say that is there like the laws of let's say the laws of Hammurabi is applicable in that system more than common law, or this is a completely different doctrine?
The laws of what? I didn't hear the last word.
Hammurabi.
Okay.
It's the eye for an eye.
Oh, I mean, I think it'd be completely different. Okay. I think you've got Latin America is its own animal. Okay. With that, I don't think none of that's applicable.
Okay, so let's move on to the next one. So now we talk about a lot of the differences between common law and civil law, but how about some similarities between the two? And I spoke with Jorge regarding the Mexican like the courts in Mexico, how it tend to actually make their rulings, which is in the procedures, which is completely different than our system here in Florida. Which every time that he sees like court cases here in Florida, is sort of a little bit taken by surprise about how expensive it is in terms of depositions, discovery, and so forth. But what are some similarities between the two?
Well, I mean, in each case, you still have to take evidence. Okay. For example, in some of the cases I manage, you're going to have witnesses testify to the chain of title. You're going to have an expert like a surveyor testify that this is the study he did on the property. These where the meets and bounds are, and this is what we believe is the plaintiff or the defendant's property. So what normally happens in those cases, and obviously the surveyor for the plaintiff and the surveyor for the defendant are going to disagree. So the court appoints a third party independent surveyor. It's supposed to just provide truth and justice to make a decision based on the input from the two expert witnesses. In the US, courts normally don't do that. They're going to, at least the cases I've seen, you have the plaintiff's expert, the defendant's expert, and the judge will make that determination. They will not appoint an independent expert, let's say, to make that kind of decision. So the similarity is, yes, you have expert testimony. The big difference is that in Mexico, for example, they'll appoint what they call a perito en discordia, which is, okay, the court appointed, which will make a decision upon which the court can rely on. Then the judge is free to either rely on the court-appointed surveyor, say, or the plaintiff surveyor, or the defendant surveyor. Those are just a couple of, of key differences.
Okay, so let's move on to the next slide. So maybe we can have some views about how the hybrid system work. And I think Brazil has a hybrid system as well of common law and civil law. Are there any other countries where you have experience with this hybrid system? And I think also Israel has a hybrid system as well.
I think so. And I think I looked at some issues in Malaysia, which have a hybrid system, which basically means that, you do have case law precedent, in addition to, a civil code, let's say. And,
Right.
and you will have juries where people are present to be the trier of fact. Okay. But those hybrid systems I've seen very few of those systems.
They tend to be very rare in aspect of applicability. But have you had the chance to see a hybrid system in action?
No, I've never managed litigation in a hybrid system. I will tell you something that's interesting, though. I did manage litigation where the criminal case was collateral estoppel for a civil case.
Wow.
So once the criminal court decided, say, fact A, okay, then the civil court was bound by that fact.
That is interesting.
And that's happened in Romania, actually, where I have certain matters pending. So it's an interesting anomaly where criminal case and civil case are pending at the same time, and sometimes the criminal and the civil case is merged. And so the judge is taking evidence on the criminal case as well as the civil case.
That is very interesting. And for just the background, collateral estoppel, it's an issue preclusion that I was already litigated in the past. And therefore, when it's relitigated again, then the defendant can actually give as a defense a collateral estoppel saying, we already talked about this issue. It's not been resolved while we were back at it again. So
Well,
like this.
yeah, but what's different about it, though, it's a separate court making a decision for another court. In other words, the court decides fact A, okay, then the second court, the civil court, has to say, well, since the criminal court decided fact A, we're not going to litigate that anymore. And therefore, we're going to take that as given.
That's very interesting to see. It is, which country was it in? And it was it
Romania.
Romania. Oh, very interesting. I didn't like that's the first time I hear that the civil courts take on the criminal court and they merged in one. This is fascinating because here in the United States is a big no-no here.
Yeah,
For
and
sure.
then, of course, the burden of proof is different. And, I'm sure from what people see on TV, proof beyond a reasonable doubt. And, in civil cases, more likely than not. But it was fascinating for me to see the difference, and to see
Right.
how it's played. And honestly, if you're not litigating in the criminal case because you're not the defendant, the question you have to ask yourself is, do you intervene as an interested party? You know,
Right.
there's a risk to that, because if you intervene and you lose, then that's even worse for you in the civil proceeding.
Mhm. No, that's very interesting. And I have a question to ask you regarding the civil court. Actually, you just brought something very interesting in terms of criminal cases. Uh, what's the threshold? Is there a threshold? Because, for example, here in common law system, certainly in Florida, we have by preponderance of the evidence that we have to prove our case. But when you go to criminal cases beyond any reasonable doubt, what's the threshold? How would that work in the civil law system?
Well, the civil law criminal system is extremely complicated, okay? Because that's something that's done by what they call the public ministry. And that entity decides if there is a crime, okay? And yes, the burden is higher in the criminal law system and civil law system than it is in the civil law system. It definitely is higher. I don't know that they would turn it, beyond a reasonable doubt, but there is something similar to that. Where I've had experience on criminal cases has been in Mexico, and there are a number of procedural crimes uh, to which you can be charged, but you almost have to have a private lawyer to help you pursue the criminal case, because of course the public ministry is not going to move it unless you move it.
Right.
And something that's, going back to the common law system, for example, in the UK, you have such a thing as private prosecution, where you as a private citizen, say you want to have somebody prosecuted for fraud, can actually file a criminal complaint with the judge. The judge could issue an arrest warrant. You still have to present the evidence. You need a barrister to litigate it. But those are cases where, say, that a crime was committed, but the British government doesn't want to prosecute.
That's very, very interesting, because here in the United States, we of course we charge the person who committed the crime on you as a victim, and then the state attorney sees if it's going to go forward with those charges, and then they decide to proceed or not, and if they have enough evidence beyond reasonable doubt to prove their cases. So it's very, very interesting to see the cultural differences and also as well the different legal system. But let's move on to the next one. Let's see. Uh, so, okay, so now we're going to talk about international arbitration, because we know that our world is getting more and more interconnected. Today we have Zoom, we have international trade playing at stake right now. Everybody knows about what's going on regarding Ukraine and regarding Israel, unfortunately. And everybody is well aware about the globalization issues. And thus, I think international arbitration is going to play a bigger role than it ever. It's increasing its role than it ever was before. What is your take on the international arbitration of bridging common law and civil law together?
Well, a few years ago, I was probably, I wouldn't say anti-arbitration, but was very suspicious of arbitration. As I got to, and I was involved in a number of arbitrations. I think arbitration in generally, I think the fear is that, they split the baby, can there be corruption with the arbitration? Um, those are things that you consider, but as I've handled more and more arbitrations, I think it's a great system to merge the common law and the civil law system, because you can borrow from each, let's say, but it's a system that would probably promote, say, more transparency. And especially if you're required to disclose evidence. You see, unless you know what the other side has, it's difficult for you to go to your client and say why you should settle a case. Okay. I think it would, international arbitration proceedings, I think, would promote settlement more, because there's disclosure. And I think it allows you to see the other side's evidence. I think it, allows them to see your evidence. And so, you can see weak points and bad points. I know that, for example, depositions never happen in civil law jurisdictions that I work in. So you're never going to take them. In some countries, you can't even talk to the witnesses. That's the purview of the judge. So you don't necessarily know what's going on. with your case, and these witnesses testify, you don't know what they're saying. That's like horrible to a common law lawyer who prepares his witnesses before trial. But civil law systems are so freakishly overcautious about influencing a witness that that you have to be careful how you talk to the witness and what they're going to say. But I think international arbitration is like the one device that will mix these two processes. Now, the question is, which rules are going to apply, right? You've got so many, they're probably about, listen, somebody was telling me, a German lawyer I work with, there are 2,000 arbitral institutions throughout the world, okay, for different industries. There's Arias US, Arias, UK, which is reinsurance arbitration. There's consumer arbitration, there's expedited arbitration. So yes, I think it does bridge the gap. It's a long-winded answer to say, yes, it does bridge the gap, and this is why. I think now the other issue that's very problematic in civil law jurisdictions is, the corruption of the judges. In other words, you're less likely to get somebody corrupt as an arbitrator, but there's always allegations about the possibility of corruption. One of my Chinese lawyers says that you don't want to arbitrate under the Chinese arbitration code. You're better off in the commercial court, Chinese commercial court. So there's no clear answer to that.
So, well, this is why, based on the backgrounds for my clients, I always advise to them to have an international arbitration clause when we do international transactions, because there's that separation of cultural background in different legal system that makes us not comfortable to follow with or to kind of dive into it. And I always advise them that international arbitration would be a much better avenue to streamline all the legal disputes and make it less expensive down the line than having multiple issues in different jurisdictions. But this is why I'm very in favor of arbitration when it comes to international transactions. But what I saw so far, to my experience, is that exceed cases, or I would say investor-state dispute settlement, have a hard time to settle with the governments. Do you have any comments about this sometimes?
Well, I think the bulk of the litigation in international adoption is whether you fall as a proper party under the treaty, right? I mean, what's the purpose of the investment arbitration? Is the government is not complying with it. You don't want to sue the government in their court system, right? Because you fear that they may have some undue influence. So you have these international courts like NAFTA, you have the WTO, the World Trade Organization, they all have their courts. I think investors prefer to have the arbitration rather than being in a court, because the government always has the home court advantage. Case you wrote about, the Metalclad case, is a case I teach in law school class. It's a NAFTA treaty. It was a plant that was a waste disposal plant in San Luis Potosi, that they had the approvals, and then local governments interfered, and basically Metalclad sued saying, you took my property even though you didn't really take it. You made it so useless it was a taking. Okay. That case probably would never have been won in a Mexican court, but it would be won in an arbitration. And I've had several friends in Mexico, for example, who've litigated gotten multi-million dollar verdicts against the government of Mexico for violation of the investor agreement. The problem you get with the investor arbitrations is who qualifies as a party. Okay. Are you a national or are you not a national? Where you live is important. I'm sure you've seen that too in your practice.
Yes, of course. And one of the last cases that we were dealing with was a mining company in Panama against the government of Panama, but we went up to not go forth with this arbitration. But we had a problem with dual nationality, where the exceed rules specifically, and I've spoken this with Professor Para, who was the previous counsel of the World Bank, that the exceed rules prohibits dual nationality. Meanwhile, the institutional rules are not having a voice about the situation of dual nationality. But on that aspect, we had an argument saying that he invested as an American and not as a Panamanian, and that the investments came from the United States and not as from the Panama directly. So it could have worked at that point. Unfortunately, we just did not go forward, and that's what happened. That was the closest case that I had under transnational matters. Otherwise, it would have been under the previous cases that I had experience with Hogan Novels. Those are actually a fascinating case. Certainly, the one with Mr. Leachin, it was an ICC arbitration against the Dominican Republic for investor FET, which unfair and inequitable treatment and expropriation. But other than that, this is a huge issue of dual nationality, and there's a constant debate about it, and constant debate about dual nationality. Should it be allowed for dual national to follow arbitration and to file under their proper BIT? And it's very, very, very complicated and complex as to how this is treated per rules. It depends on the tribunals delivering the arbitration under the BIT. But what we also saw is that we had a change with NAFTA, and maybe you can comment on this. Is that now NAFTA has been replaced by USMCA treaty, which now that we saw that Canada has opted out of arbitration under the USMCA treaty. But he also, what he did is that he entered into what's called CAFTA with Europe, where actually they set out their own tribunals with their own judges over there. I think it was 15 arbitrators that are set out under CAFTA. So I would just, are you aware of this situation about what's going on with USMCA and CAFTA as well?
No, well, Kafka, what are the initials? What does Kafka stand for? Because there's Kafka, there's a central, American trade agreement, right? But Kafka, you're saying is European?
Let me look this up. Hang on, because I don't retain the trade agreements. Hang on.
So you're saying that Canada pulled out of the new NAFTA treaty?
Right, Canada actually pulled back of arbitration under USMCA. Okay. So, for example, Mexico, if foreign investors actually are investing in Canada from Mexico, they can't no longer do it under the USMCA. It's not under the BIT anymore, or multilateral agreements that they have under NAFTA. And they just opt out from it. Mexico is still in it, and US is still in it, but I think Canada, there was a problem with arbitration over there, and I think there was a study showing that Canada was not in good positions under those arbitral proceedings.
Probably, I imagine Canada felt that they weren't getting an even, great arbitral decisions based on what arbitrators do, right? I think the reverse is true for Mexico. I mean, having litigated and not managed litigation in Mexican courts for a while, those courts are extremely cumbersome. Okay. And I think it'd be a mistake for Mexico to pull out as Canada did, because one of the things that inspires confidence for US investors or any foreign investor, well, US investors per se, because of the treaty, is the fact that they can go to this arbitration proceeding outside of the court. Okay. I've got cases in Mexico that have been litigated since 2010, and they don't seem to come to an end. And arbitration would bring those cases, to an end. If in the Metalclad case, they would have had to litigate that case in San Luis Potosí, that my 18-year-old would be a 20-year lawyer before that case ends. Okay. And then you got a local judge who's got the home court advantage, say the local government putting pressure on the judges to make these decisions.
Of course. I apologize for that. I mixed CAFTA with CETA, which is the trade agreement that Canada has been involved with Europe.
Okay.
Yeah, I confuse those two every single time. I just don't know why.
Right.
It's the EU Canada trade agreements that's still an ongoing basis, or the EU Canada Comprehensive Economic and Trade Agreement, which they established their own tribunal under CETA. They did not follow exceed. They didn't use any existing tribunal, but formalized their own tribunal, the CETA. And I think like you're right. I think actually Canada did not feel that he was having the treatment that he felt just not comfortable with arbitration because of that treatment that they had under those investment disputes. But I have spoken with the Canadian government about this when they invited me to talk about the USMCA treaty. And I think, for my belief, I just don't think it was a bright move for Canada, because it's trying to attract investors to go to Canada. And I thought that it could have been one of the moves that he should stay in arbitration to attract these foreign investors. But unfortunately, they didn't feel the fair treatment. Do you have any comment on this?
Yeah, I would think, in other words, I would feel more comfortable. I've never litigated in Canada, but I've had colleagues who have litigated in Canada. I would feel more comfortable probably in a Canadian court than I would in a Mexican court. Okay. I would not have the same worries and precautions that I have in Mexico with litigating. So I think, people who want to invest in Canada probably feel safer in Canada than they would any place else, or than most other places, right? I mean,
Right.
the whole purpose, at least in my mind, of having these investment arbitrations is so that people who are going to put out millions of dollars to invest in the country want to be able to get a fair shake if there's a dispute. And I think people would generally feel the Canadians' legal system is as sophisticated as the US or any other in Europe, and they can easily avail themselves of the courts. I would say another reason why international arbitration is bridging the gap, because the key difference between common law and civil law systems is, in common law system, you're not entitled to attorney fees unless there's a statute that provides them. For example, race discrimination statutes, sex discrimination statutes, they have a provision for attorney fees, unless there's a prevailing party agreement that allows for attorney fees. But as a matter of course, in civil law countries, the loser pays the fees. And those fees can be very, very significant. So, for example, in Mexico, if you make a demand for $60 million and you lose, you could end up paying the winning party 20% of what you're asking for. So 20% of 30 million, what is that, 6 million? You get that. And also, in some of the systems, even in the UK systems, you pay costs. So if you file a motion to dismiss and you lose, you pay the other side's cost for that motion to dismiss. So
Right.
Arbitration is a way to take that expense out of litigation. You arbitrate, you can have an attorney fee provision clause in there, but most of the time, everybody pays their own fees, and winner or loser. But you're looking at quite a bit of exposure. A case that's long been over for me, that I lost it at the trial level. We were condemned to $17 million on a fake contract through a fake power of attorney. And when we ultimately won on appeal, the cost would have been $3 million that we could have collected. By then the company was sold and the other company wasn't interested in, pursuing the cost. But that's a key difference, is the costs are significant. And so what that does is that can discourage people from filing a lawsuit.
Right. Right. And this is probably why we see like companies like Tesla's, or even like Sony, even Apple, when you have contract of adhesions, they actually have arbitration clause for those consumers, or they have arbitration clause for employment lawsuit or disputes. It's just to not have any sort of class actions down the line, and also as well to dissuade those potential plaintiffs from filing a lawsuit. But is this something that is it very fair at this point to take away or try to deter these parties from filing lawsuits because it's very costly at the beginning to start an arbitration proceedings? What's your take on this?
Well, the fact that you're talking about consumer arbitrations, you're talking about, you're not happy with Amazon, for example, and you consented to arbitration with them. So you write in, AAA or some other entity. But that hasn't prevented class action suits, because what you have are mass arbitrations. You've got, a lawyer that represents thousands of people, say, who are upset at Amazon. So in a sense, you do have, the class action. Look, in a way, I think the consumer arbitrations are fair, and this is why, okay? Because you're generally not talking about large amounts of money, okay? Which means that the average person has to hire a lawyer to represent them on this case. If, you can go to small claims court, but even then, small claims court, you don't have to have a lawyer. You file it. In most states, it's an amount under a certain level that you can do it, but you're not a lawyer, you don't know it, okay? What you do as the consumer is you have a way to vent. You say, this is what they did wrong. And if you win quickly. If you lose quickly. But it doesn't require you to go to court. Now with Zoom, you don't have to go anywhere. I think it's an expedient system, and although it's imposed, and they are contracts of adhesion pretty much, it's take it or leave it, But I think there's some fundamental fairness to it in that sense, and that it makes it easier. Because the consumer doesn't pay the arbitration fee, right? Consumer says, I want to invoke the arbitration. Company, I believe the company pays for it, and you present it. And if you win, you get your money much sooner, right?
Right. Right. I mean, it depends to my experience with arbitration, it depends under the contract. I've seen contracts drafted, but that's on a consumer basis. Those are our business transactions where the claimant would be responsible for the initial cost of arbitration, and whoever wins the arbitration would be able to recuperate cost. Sometimes I see clauses that been drafted that claimant and respondent would be half and half on cost of the tribunals. And sometimes it's just determined at the end. It depends on exactly the type of clause that we see under the contract itself, if claimant would be responsible at the beginning. I don't know
Well,
if you have anything you would like to add on this.
well, but see, in some countries, you have to post anticipated cost, okay, and it could be a significant amount. But if you're talking about big contracts, the primary concern is not always the cost. Now, I've seen a number of arbitration clauses where there's no prevailing fee portion. Each takes their ball and go home after they finish the arbitration, okay? And like you, I've seen a number that have the prevailing. But, you can always decide if you're going to settle to walk away. You know what I'm saying? It becomes difficult to settle in some of these civil law systems. I mean, you can settle, but I find the systems I've worked in, you can't, for example, dismiss a case. If you dismiss the case, I've had one case where we tried to settle with one party, but we couldn't resolve the issue of cost. If it would have been an arbitration, we could have done that.
Right. Okay. So technically, just that's what we're looking at for arbitration, and I believe that for that perspective, international arbitration is a great avenue to bring in gaps of globalization and having a trusted system that can work when you're involving international transactions. So that actually comes to an end to our presentation about the implication of civil law and common law. So to your knowledge, where are we heading with those two systems? Do you ever think that these two systems will eventually merge into one system, or or this is something that's way too far away to think about at the moment? What do you think about the future?
I don't think the systems will ever completely merge. I think there will be some characteristics that countries adopt. Uh, you know, for example, with the presentation of evidence in front of a jury, for example, in Mexico, okay, on criminal cases. I think that there will be some globalization. I will say that the similarities will become more similar, but it'll never be totally integrated. Okay. And I
All right.
also, yeah, and I also think, just, to add one more thing, um, the attorney in the common law system has to have an open mind. What I find with many U.S. attorneys that have to deal in Latin America, well, what do you mean there are no depositions? What do you mean there's no, discovery? That's surprised. And I'll say to lawyers I'm working with, you got to stop asking that, because it makes you sound like an amateur. Okay. What you have to do is put yourself in the mindset of that system. And I tell the civil law lawyers too, because I've got cases that are, all over the place in multiple jurisdictions on one matter. And the civil law lawyer also has to get his mind around the fact that the U.S. client, okay, has a certain expectation and has to adapt himself to the expectation of the person who's paying the bill.
Right. Right. And it is different type of cultural background in those legal system that makes it harder for attorneys that are not well, how do you say that are not internationally or exposed to different culture, and this could be problematic down the line. But without further ado, I want to ask you one more question regarding attorneys in the civil system and attorneys in the common law system. And I sort of know exactly what you may answer about this, but a lot of attorneys that I spoke to in the civil law system who came to the common law system and did their education here and practice here today, they always told me that the common law system attorneys have a super analytical skill over the civil law system attorneys, because it's so over analytical in terms of having these argument under precedents. What's your comment on this? What do you think about these type of system, and does common law, what does common law do right, and what does the civil law do right?
You know, let me backtrack before I get into that question. Okay. When you're talking about civil law lawyers and you're hiring a lawyer in the civil law system, you have to see what the licensing procedures are for attorneys in those systems. Okay. You would be surprised to learn that, for example, in Mexico, there is a bar, a Mexican bar, but a Mexican attorney can never be disbarred. The most you can do is sue them. Okay. Guatemala, for example, has a bar that can turn. So you have to look at how that, because one of the things that keeps attorneys honest here and in Europe is the fact that there's a bar looking over us to make sure that we don't conduct ourselves in an unethical manner. And even that, there attorneys who get disbarred, right? But you don't have any protection in some countries on that. So selecting the attorney is very different. If I had to choose, I would say that and my civil law friends will probably kill me for this answer. The common law attorneys have a more, I say, a different skill set in leaving no stone unturned. Let's look at everything. Where civil law attorneys have a tendency to say, this is what the statute says, this is what you can do, and this is what you can't do. I'll give you a classic example. In the one case I had, it's all over with now, so I can talk about it, and we've sold the company. I interviewed everybody in the factory, and I said, I want to talk to everybody. I want to know what they're going to say. The mindset of the common law lawyers, we want to know, good or bad, what it is. When we get to the last witness, after we've interviewed 10 the whole day, my lawyer says, well, this person signed the fake contract. So he's obviously going to be on their side. And I said, well, I don't care what he's going to say. If he's willing to talk to me, he's going to talk to me. And he said, this witness said, oh, yeah, I signed the contract, but they forced me to sign it. The factory was closed and they keep threatening me. And that person was our best witness. So I think civil law attorneys need to look beyond a little bit, because people said, you're going to lose that case. What do you mean you're going to lose that case? Because the power of attorney was so broad that he could have sold the plant manager could have sold the factory. Okay. You're going to lose it. You're going to lose it. You're stuck. I don't care, but I'm throwing everything in the kitchen sink. Okay. And it turned out we were able to prove that it was a fraudulent contract, that there was a conspiracy between these two people. But people just looked at, oh, the power of attorney says he can do it. He can do it. The civil law lawyers don't necessarily look beyond that. Okay.
And
As
this
I
is
said,
why, sorry
as I
about
said,
that.
they're hearing me, and they may say, Rudy, you're full of it. But that's my perception.
No, of course. I mean, this is why we had an ongoing debate with those civil law attorneys and common law attorneys saying that we need to stop the discovery and arbitration. And the common law attorney says, but we need to find out if there was fraud. So, so that's why that's why the American attorneys tend to look way above and beyond to every document they can get their hands on. Absolutely. If we have an extensive discovery procedure on the American system. So, but I want to put on that note one final note about this is that why our system in the United States is so much more famous than any other system, and I think actually movies have to do something with this, right? Would you say the same?
Yeah, really love watching lawyer movies. I've seen every Perry Mason movie, and when I was, in junior high school and I wanted to be a lawyer since that time, I saw every Perry Mason episode probably more than once. I saw every lawyer movie. So the movies have dramatized the role of the lawyer. Half the stuff that happens would never happen in a courtroom. Okay. Boston Legal with Denny Crane and LA Law. Those things don't ever happen. I think the US system maybe has more, in a sense, notoriety because of the flair for the dramatic. Some of the best lawyers in the US have been very dramatic people in presenting a case, and I've given some, seminars, not seminars, but seminars to some Mexican lawyers on how to present evidence. And I say to them, look, even though it's documents, you're still going to have to tell your story. Tell your story to the judge. And so what happens when it comes to an arbitration, these people are not trained necessarily in the art of oral argument, in the art of presenting the evidence, in the art of presenting testimony. And so that's a skill they need to acquire. And there are a lot of companies giving seminars on these types of things in Mexico.
Of course. And well, one of my favorite movies is My Cousin Vinny. Not because it's also one of a it's very hilarious to see this in court, but it's also very accurate in terms of procedure. I think if it did a very well done movie in terms of procedure in the court. So, what do you think about this? I think that actually it's one of the few movies that law school students watch when they're in law school specifically to learn civil procedure.
Well, when I was in law school, The Paper Chase was the movie that they showed, with Professor Kingsfield. For me, My Cousin Vinny was more about you don't have to be the brightest person in the world. You have to be prepared. Mm-hmm. And the more prepared you are, the better you are at cross-examination.
Right. Right. So, anyways, we have come to our end to our presentation here. And definitely we had a very long discussion about the two legal system that we're facing here. I'm going to leave the floor open to questions. If anybody has quick questions, I know some people may have been on LinkedIn. I don't see the number of attendees, but feel free to ask any questions. If you're on Zoom, you can unmute yourself and ask questions as well. Feel free to do so. And we'll be waiting patiently on any questions you would like to ask Mr. Rivera regarding the two legal system the civil law and the common law system in the international arbitration. I think you also are you're becoming an arbitrator, right? Are you a AAA arbitrator yet, or?
Yes, I'm on AAA's panel. I'm on NAM's panel. That's just recent. I will probably start, well, doing arbitrations in the near future.
Do you believe that you're going to be also on Exceeds panels and ICC panels more in globalized arbitration? You seem to be more fit for them.
You know, it's being an arbitrator. Unlike in a court case, you have to select the arbitrator. Okay, and there is a lot to choose from. A lot that are very qualified, some that aren't so qualified. So you just have to get into the mix where people know you and they'll select you.
Right. Right. Absolutely. I totally agree. Sometimes it just doesn't seem to be coming for above. And to my experience with arbitration, every single time we propose arbitrators on the list of from 1 to 10, because that's how some tribunals does. Certainly, AAA does it when they propose arbitrators, and we have to select them from 1 be the first one we want to be in front to the tribunal, and 10 to be the last one we want to be in a tribunal. They always object to each other. Like we're just not agreeing about who's going to be on the panel. So,
Well, but you can also suggest arbitrator names. You can also
no, of
provide
course,
suggest,
of
say,
course.
we want these people to be arbitrator. Um, you know, if there's any piece of advice I can give your audience, and that is when it comes to arbitration, most of the time the arbitration clauses are ill drafted. There's not much thought. And I compare this to the song by Meatloaf, Paradise by the Bad Dashboard Light. You know, you're in love, you're dating, you're going to get married, it's going to be something for the rest of your life, and you don't want to talk about divorce, okay? But you have to understand, in a situation where you're entering a business relationship, it's going to end somehow or another, either on its own or it's going to end in litigation. And what I've seen in a number of contracts is they throw an arbitration clause in there and that's it. They don't give any thought. No
No, of
selection
course.
entity, no, it doesn't have to be completely detailed. But for example, there's a clause that says, hey, arbitration will be guided by the federal rules of civil procedure. Well, the purpose of arbitration is to streamline it. The federal rules of civil procedure aren't going to streamline it, okay? People spell out the number of depositions. In one case that I go over, which is the Bremen versus Zapata. That's the leading Supreme Court case on form nonconvenience. That's when the Supreme Court said it's all right for people to do that. But the arbitration clause said the case will be handled by the High Court of London. There is no High Court of London. You see what I'm saying?
I think they have the London Court of International Arbitration, LCIA, over
But
there.
that's
But
not the High Court of London. You know what I'm saying? That's not the High Court of London. And people will say, well, I want non-binding arbitration.
that was the point of it. I mean, it can help to settle the case early on.
You know, as much as I recommend people doing that, not doing that, I actually did it once on a on a separate matter, not related to my company, where it was the deal breaker. Okay. It was the deal breaker, arbitration or going to court. And it's the reason we decided to put non-binding arbitration, because after talking to my client, we said, well, look, if an arbitrator says no, do you want to litigate? No. I talked to the other side. Okay, look, if we win in arbitration, are your people inclined to litigate? Probably not. So we took a chance and we put it in there. We put non-binding arbitration. But any other agreement, I say, oh my God, that's the dumbest thing you can put in there. And here, I did it on the case because it was a deal breaker, right? So never
Yeah.
say never. Never is a long time.
It's very interesting because I've been in court cases when actually the judge gave us it was forced us to go to non-binding arbitration here in Florida, and it was a huge construction condominium development cases that I've dealt on. I was on the defense side, and we had barely any time to file. We were very late at this point to file our legal memorandum or the statement of the response to the statement of claim from the plaintiff side for the non-binding. But we didn't have a hearing. It was just one document, the other guy the response, and that's it. That's all there is. And then the arbitration makes a judgment regarding these documents, which is non-binding, and then forcing the parties to settle, or maybe actually pushing the parties to settle down the line. So I've dealt with non-binding arbitration. They're very interesting because there's different type of procedures for settlement of mediation. Certainly, you have like a bondsman, and you have other type of international aspects that's being recognized under the ADR. It's not only arbitration and mediation. There's a bondsman. There's mini trials. There's some sort of like that can be also implemented into the aspects of ADR. Which was very, very interesting to see that they're not well famous, they're not well practiced, but they're there. It's a very, very possibility. I don't know if you've heard about these issues of ADR, alternative dispute resolutions, beside mediation and arbitration.
Well, most of the times they're included in contracts that you're required to do a mediation before you can invoke arbitration. And the reason for that is to allow the two business units to get together and try to work out on a business solution. Okay. And so that's mandatory. And sometimes the business units really meet in earnest and say, what's the problem? But there has to be somebody with decision-making authority on each side, you know, to say, yes, look, companies live and die by the quarter. Okay. You know, how much are you spending this quarter for attorney fees? What's your liability for the quarter? But they live and die by the quarter. And so, you know, these arbitrations, you know, you force people into a mediation in the contract so that you can try to work it out so you can avoid that.
Right. No, of course. But I think this is a very comprehensive aspects of ADR when we're dealing with international transactions in those avenues. But I believe I did not get any questions on LinkedIn so far. And I think, do you have any closing remarks that you would like to provide, Mr. Rivera?
Yeah, I would say no matter what system you're in, if you're a civil law lawyer working in a common law system, you know, you're a common law lawyer working in a civil law system, you have to keep an open mind, okay? And you have to think outside the box. And don't ever accept an answer because that's just the way we do it here, okay? Dig deep and ask questions why. If you're a common law lawyer litigating in a foreign jurisdiction or managing litigation in foreign jurisdictions, don't just take the lawyer's word for it. Explain to me why it's important. Explain to me why you have to do it this way. Don't just say that's the way you do it here, you know. And the civil law lawyer has to understand that, you know, companies are used to a different legal system. So they have to adapt their reporting requirements, how they interface with the clients, because it's not just about the law, it's about client interaction, okay? So both have to understand that there are nuances to each and be open to those separate nuances. And otherwise you get in fights, you get in trouble, you know.
Of course. Well, and to that end, we actually ending up at 10:30 p.m. almost. And I would like to thank Mr. Rivera for this discussion. It was a very insightful to know about the civil law system and the common law system and how international arbitration bridged the gap between these two systems. And I'm sure that we can. It's not the only time that I may ask you to come again for another podcast, Mr. Rivera. I think we'll probably see you for another topic down the line, for sure. So, and maybe down the line also as an arbitrator as AAA. That would be great to see, and to see you also on the ICDR cases on AAA. But it was great to have you. Thank you so much for coming online with us and discuss these two systems. And hopefully we'll also stay in touch together here and keep on discussing this system and keep on learning regarding these two legal systems that differ from one another. I don't have anything else to provide. Besides that, we are Transnational Matters. We also represent clients globally into their international transactions and also advise clients into their foreign investments and also international contracts and also in commercial litigation here in Florida. We represent them also at the ICC, Exceed, and also we have had cases at CTAC in the past in China. So we are well versed into international law and how it functions and how to kind of guide you through to the complexities of international law. We're going to keep doing those podcasts. This podcast help educating non-lawyers about these systems and how to navigate them. And down the line, make sure to make the right decisions. And that's the point of the podcast. The podcast is to not necessarily educate lawyers, but how about non-lawyers so we're not aware and delving into these international transactions without knowing what type of systems we're going into and how can it affect them in their businesses down the line. So that's the point of these things. And I hope to see you again, Mr. Rivera, and we'll definitely keep in touch.
Sounds good. Thank you very much. If you want to stay on after you stop broadcasting.
Yes, I'm going to stop broadcasting right about, give me 1 second, if I can know how to stop recording. I haven't done recordings here in the past, so, okay, here. Okay, so
Are you
I'm
still
gonna,
live streaming?
yeah, I'm gonna stop the live streaming. Give me 1 second. Is it Restream.io? Okay, here.